So stand. All persons having any business before this honourable court now draw nigh. Give your attendance and you shall be heard. God save the Queen.
Admission of lawyers. Gang Yu Chen.
May it please the Court, I move that Gang Yu Chen be admitted as a lawyer of this honourable court.
That Gang Yu Chen be admitted as a lawyer of this court.
Christina Dang.
May it please the Court, I move that Christina Dang be admitted as a lawyer of this honourable court.
That Christina Dang be admitted as a lawyer of this court.
Rebecca Dobe.
May it please the Court, I move that Rebecca Dobe be admitted as a lawyer of this honourable court.
That Rebecca Dobe be admitted as a lawyer of this court.
Stephanie Evstathiou.
May it please the Court, I move that Stephanie Evstathiou be admitted as a lawyer of this honourable court.
That Stephanie Evstathiou be admitted as a lawyer of this court.
Fernando Espinosa.
May it please the Court, I move that Fernando Espinosa be admitted as a lawyer of this honourable court.
That Fernando Espinosa be admitted as a lawyer of this court.
Nancy Maria Fagali.
May it please the Court, I move that Nancy Maria Fagali be admitted as a lawyer of this honourable court.
That Nancy Maria Fagali be admitted as a lawyer of this court.
Nabila Heda.
May it please the Court, I move that Nabila Hida be admitted as a lawyer of this honourable court.
That Nabila Hida be admitted as a lawyer of this court.
Taylor Grace Kennedy.
May it please the Court, I move that Taylor Grace Kennedy be admitted as a lawyer of this honourable court.
I'll let Taylor Grace Kennedy be admitted as a lawyer of this court.
Heidi Knight.
May it please the Court, I move that Heidi Knights be admitted as a lawyer of this honourable court.
That Heidi Knights be admitted as a lawyer of this court.
Hugh James Marks.
May it please the Court, I move that Hugh James Marks be admitted as a lawyer of this honourable court.
That Hugh James Marks be admitted as a lawyer of this court.
Eliza Constance McCabe.
May it please the Court, I move that Eliza Constance McCabe be admitted as a lawyer of this honourable court.
That Eliza Constance McCabe be admitted as a lawyer of this court.
Salonika Mitta.
May it please the Court, I move that Salonika Mitta be admitted as a lawyer of this honourable court.
That Salonika Mitta be admitted as a lawyer of this court.
Kate Rose Murphy.
May it please the Court, I move that Kate Murphy be admitted as a lawyer of this honourable court.
That Kate Rose Murphy be admitted as a lawyer of this court.
Xiao Tian.
May it please the Court, I move Xiao Tan be admitted as a lawyer of this honourable court.
That Xiao Tan be admitted as a lawyer of this court.
Grant Christopher Hayes Toolman.
May it please the Court, I move that Grant Christopher Hayes Toolman be admitted as a lawyer of this honourable court.
That Grant Christopher Hayes Toolman be admitted as a lawyer of this court.
Jane Mvanwe Worth.
May it please the Court, I move that Jane Mvanwe Worth be admitted as a lawyer of this honourable court.
That Jane Mvanwe Worth be admitted as a lawyer of this court. It will be necessary for the purpose of an oath or affirmation that all those being admitted today stand up, but please remain in your current places. Could all admittees please stand?
Wang Yu Chen. Christina Dang. Rebecca Dobe. Stephanie Evstathiou. Fernando Espinosa. Nancy Maria Fagali. Nabila Hida. Taylor Grace Kennedy. Heidi Knights. Hugh James Marks. Eliza Constance McCabe. Salonika Mitta. Kate Rose Murphy. Xiao Tian. Grant Christopher Hayes Toolman. Jane Mvanwe Worth. Do you severally swear or declare and affirm that you will truly and honestly conduct yourselves in the practice of a lawyer of the Supreme Court of New South Wales, and that you will faithfully serve as such in the administration of the laws and usages of this state, according to the best of your knowledge, skill, and ability. Would you please say, "So help me God," or "I do"?
I do.
Please be seated. Now that the formal part of the proceedings has ended, I'd like to warmly welcome you to the Supreme Court of New South Wales. Present with me on the bench today is Justice Brereton to my right, who is a member of the Court of Appeal, and Justice Kavanagh to my left, who is a member of the Common Law Division of the Court. Together, we constitute the court that has, in exercise of its jurisdiction, admitted you to practice. As we gather here today, I would like to begin by acknowledging the traditional custodians of the land on which we meet, the Gadigal people of the Eora Nation, and pay my respects to their elders, past, present and emerging. We recognise the long-standing and enduring customs and traditions of Australia's First Nations and acknowledge with deep regret the role our legal system has had in perpetrating many injustices against Aboriginal and Torres Strait Islander peoples. To all the new lawyers here today, welcome to the legal profession. Today is a day for celebration. You have all worked extremely hard to get here, through caffeine-fuelled nights and obscure problem questions, reading countless wafer-thin pages of textbook and more cases than you can hope to remember. Rest assured, for those of you with a bibliophobia, that is a fear of running out of reading material, as lawyers, that fear will never materialise. You have entered the world of eggshell skulls, encountered a mysterious reasonable person, and have understood the Constitution consists of so much more than just the vibe of the thing. In becoming a lawyer, you have today joined a centuries-old profession with ancient origins. The custom of advocates swearing an admission oath dates back to the 12th century. This court first admitted lawyers to practice in 1824, and by 1830 the names of lawyers were entered onto rolls in this state. You have now become part of this tradition almost 200 years later. Perhaps for some of you, or more likely for your family and friends, that feels how long you've been studying. On that note, I'm pleased to welcome those here with you today and those watching on the live stream. For many of you, the support of your family and friends, no doubt, has been invaluable. No doubt also they've been on the receiving end from time to time of your finely polished skills of argument and persuasion. I do encourage you to take the time to thank them today. The oath or affirmation you have made today is a serious one and deserves solemn regard. Whether you work in private practice, at the bar, in a community legal centre, or in an entirely different field, you should be known for your honesty, your integrity, and your commitment to justice. It is an acknowledgement of this weighty responsibility that we observe today's unique formalities, including the moving of lawyers, swearing of oaths, and even our somewhat strange choice of fashion. I recall on one occasion some years ago, a young member of the audience asked if we were doing Santa photos after the ceremony. I was very sorry to disappoint. However, although we mark this occasion with formality and tradition, not everything in the legal profession remains unchanging. You'll be unsurprised to hear that last year we had to adapt quite a bit. COVID-19 meant a rapid shift to increased use of virtual courtroom setups and technology to ensure access to justice continued in the midst of a pandemic. Things didn't always go smoothly, as those with me on the bench can certainly attest to. There have been real difficulties to grapple with in terms of open justice, effective communication and fairness to participants. And occasionally a lawyer might even get stuck behind a Zoom kitten filter. But for all the challenges we faced, the impetus is greater than ever before for us to prioritise flexibility and accessibility. Better use of technology and increased working from home arrangements have profound implications for how our legal system interacts with many people, including those in rural or remote areas, those with a disability, medical conditions or carers' responsibilities. As the newest members of the profession, you're at the forefront of innovation in the law and have a unique opportunity to see through changes so that justice is done openly and equitably. There are, of course, other changes that deserve attention. When we think of the diversity of the legal profession, we encounter the duality that we have come very far and that much still needs to be done. Though women were originally not permitted to practice, since 2018, Women have made up more than half of all the solicitors with a practising certificate in New South Wales and currently make up 63% of solicitors under the age of 30. Women occupy many of the most senior positions in the law, including, of course, the Chief Justice of Australia. However, women continue to face challenges of representation, including amongst judges of this court and, for example, barristers in speaking roles before the High Court. However, on the other hand, it is heartening to see that the local court of New South Wales has almost achieved gender parity amongst magistrates. But we must not be complacent about these issues. There are other noticeable diversity concerns that we must face head-on. Aboriginal and Torres Strait Islander peoples and people from diverse cultural backgrounds continue to be alarmingly underrepresented in the legal profession, and particularly within the judiciary and the ranks of senior counsel. We must also be alert to barriers to the profession for people from less privileged backgrounds. Law should not be a profession for the wealthy, and the idea that students may be dissuaded from studying law by the cost of a law degree, which this year has again increased, or because of other systemic issues, is troubling. Not just this, but we will only achieve a truly diverse profession when barriers to advancement are broken down and people from different backgrounds are properly supported in a collegiate and inclusive environment free from harassment and discrimination. These issues are fundamental to a just and transparent legal system and to the legitimacy of the rule of law. We need diverse representation amongst advocates and judges so that all people who become involved in our justice system can be properly heard and fairly engaged with by a system reflective of our broader community. Despite these challenges, there is real scope for change. There is far greater diversity of background amongst junior lawyers than those who've been around for as long as me. You only have to look around at the middies in the courtroom and then the paintings on the wall to see that this is so. You're in a unique position as new lawyers who are entering the profession at a time when more than ever your words and actions are having an impact for good. You're being heard and taken seriously when you agitate to correct injustices, whether it be speaking out about unsustainable working cultures, sexual harassment or bullying within the profession, unfair laws, or systemic failings affecting the society's most vulnerable. I urge you to continue to speak up for these things. They do matter. You are the future of the profession and will steer the direction it will take. As a lawyer, you will also need to make difficult ethical decisions at times. With regards to our personal characteristics, lawyers have been the butt of jokes for centuries. Some would say there are, of course, only a handful of lawyer jokes, the rest are true stories. But jokes aside, you must use the tools you have developed to think critically and not compromise on your fundamental duties to the court, the administration of justice, and other ethical duties which you must uphold. Now that you are lawyers, you can get paid to argue instead of just arguing for free. Of course, there is a lot more to it than that. You're an advisor, a problem solver, a mediator, and an advocate for the marginalised. As you go about your day-to-day work, remember that you're not merely dealing with law in a vacuum as a series of abstract concepts, but law as it applies to people's lives. For this reason, you must strive to deliver legal services competently and fearlessly, with courtesy and integrity. Justice Gageler, before he was a High Court judge, once said, "You must be prepared to give the same answer to the same questions for the same reasons, no matter who asks the question or for what purpose or in what context the asking may occur." This is foundational for upholding the rule of law. For those of you who will practice law, the way you communicate information to others will have profound consequences for access to justice. For a non-lawyer, law is often incomprehensible. One of your roles as a lawyer will be to make law accessible to others, sometimes by deciphering legal complexities, other times by deciphering poor legal drafting, and sometimes both. One thing you will regrettably strike throughout your career is legislation which seems carefully crafted with the object of ensuring that absolutely no one can understand it. Your task is not just to understand it, but to explain it clearly to those whose rights and interests are affected by it. As lawyers, we must not keep the law locked up as something knowable only to us. A client reading your advice should be empowered to understand your meaning, not mystified and confused. So be clear and concise in your writing and your speaking. Plain English is powerful. Consider, do I really need to say aforementioned or herewith? Must I sprinkle in that Latin phrase? Should I really use double negatives, tautologies and wordy clauses that take up a whole page? I would suggest that the answer to these questions is invariably no. The best advocates can make their points simply and succinctly. I'm afraid that some of the most experienced lawyers and judges can sometimes use that reminder. I just advise you not to pick up bad habits from those who have forgotten the importance of plain English. I also want to speak about failure. I'd not be surprised if there are quite a few overachievers and perfectionists in the room today. Even so, at various points of your career, you will make mistakes, some minor, some more serious. When you do make mistakes, your commitment to honesty, integrity and the administration of justice means that you must take responsibility, correct what you can and learn from these errors. You must fail at times in order to grow. What is important is that you try not to make the same mistake twice. Even as Chief Justice, my decisions have been successfully appealed to the High Court. When that happens, I'm obliged to tell myself through gritted teeth that the infallibility of the High Court is not a mere fiction, but in fact, even dissenting judgments from time to time become the law. Finally, I want to emphasise that your mental health is extremely important. This may sound unexpected at this type of ceremony, but the law is not everything. There may be times when you feel overwhelmed, burnt out or distressed. If you do, you should not be afraid to seek professional help or take a step back when you need to. Also remember that the law is a collegiate profession and in times of difficulty, the support of your peers will prove invaluable. Although you might find it hard to believe, I was admitted quite a long time ago and relied for many years on that collegiality. I lost my first case and I lost many more after that, probably more than I won. Throughout my 35 years in practice, however, I could always count on the other barristers in my chambers to share my disappointment at the unfairness of the verdict, the sly tactics of opposing counsel, and most often, I regret to say, the obtuseness of the judge or judges before whom I was appearing. I do haste to add, I don't include either of my fellow judges on the bench in that comment. On behalf of all the judges of the Supreme Court, can I once again congratulate you on your admission and welcome you to the legal profession. The Court will now adjourn.
All stand.